sound check for Erin Law's training.
Good morning. Happy New Year to everybody. I know everybody's trying to get in the swing of things, and this is actually the first time I've ever done a training like this where you're not actually in the same room, so this is a little bit different, but hopefully this will go well today. My name is Jan Zelski, and I am the Director and Forensic Interviewer at Butterfly Bridge, which is the Child Advocacy Center that serves the Chilton County area. Today, this training is kind of a second component on the Erin's Law for school personnel. Most of you have probably already done the DHR online training that's required. This is kind of a part two, which is more information for you guys to have so that you can help us as professionals better protect children in our community. And it definitely takes our whole community to do that. Today you will not only be hearing from me for a few minutes, but we have several professionals who work on our child abuse multidisciplinary team that will be speaking to you from their different perspectives. You'll hear from Marilyn Colson with the Department of Human Resources, Shane Mayfield with the Chilton County Sheriff's Office, and CJ Robinson with the 19th Judicial Circuit District Attorney's Office. So you'll have several presenters today. We hope that will kind of help keep your attention because the information we're presenting to you will be very, very important. So I'm just going to start out by giving a quick overview. Most of you by now are probably familiar with Erin's Law. It was passed in our state in 2015, and we began to implement parts of it in 2016. And so Erin's Law requires that all public schools in each state implement a prevention-oriented child sexual abuse program that first of all teaches students through kindergarten through 12th, age-appropriate techniques to recognize child sexual abuse, and it also equips them with how to tell if something like that happens, to tell their trusted adult. And also another component of Erin's Law is that school personnel have lots of training and be very well armed to know signs of child abuse, how to handle a child abuse disclosure that might happen in the school setting, and just kind of how a case might go through the system. Also, the third component of Erin's Law is that parents and guardians are also equipped with information so that they are aware of warning signs of child sexual abuse, how they can receive assistance and referrals and resources within the community. So that's kind of a quick overview of what Erin's Law is. So many of you who are watching today are actually teaching our students either the Think First, Stay Safe curriculum or the Scan or Play It Safe curriculum, which is for the older kids. So first of all, thank you so much for doing that. Since that's been implemented over the last couple of school years, children have been equipped with really great information to keep themselves safe, but also many of those kids who have unfortunately had some really awful things happen to them have gotten the information that they needed to understand that it's important for them to talk about those things. So from the Child Advocacy Center standpoint, I can tell you we've interviewed multiple children who have disclosed that they have been abused after they heard the curriculum that you guys have taught. So thank you for doing such a great job at that. As far as some statistics, when we talk about child sexual abuse, what we know is that 1 in 7 girls and 1 in 25 boys will be sexually abused before they turn 18 years old, and that's pretty alarming. I mean, just think about those numbers. And what we want you to understand today, you're going to be hearing, like I said, from several professionals in the community who actively work together for children in our community when there's a child abuse report made. And what's important about us working together is that we cooperate in this collaborative approach to cases involving children in order to, first of all, make sure that we're not causing any further trauma on the child and the family when a child abuse report is made, but also if there is something there that's happened, to also build a stronger case if the case does get to court. So those are the two main reasons why our child abuse multidisciplinary team works together as a team for these children and these families rather than independently of one another. So that team of professionals that I was talking about, many of them you're going to hear from today, involves all of our local law enforcement agencies in the county, the Department of Human Resources, the District Attorney's Office, the Child Advocacy Center, mental health providers, and also there's a medical component which is at Children's Hospital in Birmingham, Alabama. Really quickly, what we do at the Child Advocacy Center, and I know a lot of you already know this, but just so you understand what our role is. Once that report is made to DHR and law enforcement, and you will get more information about how to make that report in the next presentation, but once that report is made, law enforcement and DHR, at that point, they then contact the other agency to make sure everyone's on the same page and they know about that specific report of child abuse, so that both of those agencies are aware and can do their investigations. After they get that case of abuse reported to them, they contact us at Butterfly Bridge at the Child Advocacy Center, and they schedule what's called a forensic interview with the child. So the child is able to come to a neutral, child-friendly place and talk to a trained professional, and it's all recorded in a way that's non-leading, non-suggestive, plus the child is, like I said, in a child-friendly place. So the forensic interview is the first reason that the child would be seen at the Children's Advocacy Center. At the time we're doing those interviews, those multidisciplinary team members are there and they're watching through closed-circuit TV in real time. So that child's having to talk to one person rather than multiple individuals about the abuse that may have happened to them. So after that forensic interview is done, law enforcement, DHR continues their investigation, and they will talk with you more about that. But as far as the Child Advocacy Center, we pretty much help the family all the way from the time of the forensic interview all the way through the court process if the case does go to court. So services that we provide would be free counseling and therapy for the children and their families, support for the parents as long as the parent is not the one accused, as well as advocacy services throughout the life of the case in the criminal justice system. So that could be anything from general court prep for a child that may be about to go to court, accompanying children and their families to court, and our forensic interviewers actually testify as expert witnesses in the court cases. We also provide training such as the one that we're doing today, and we also coordinate our multidisciplinary team as well. So that is our role, just kind of in a quick snapshot of what we do. But you may be asking today, why do we need to learn about all this? So there are lots of reasons, but kind of on the top of the list for me is that more than 90% of the time we know that children are abused by somebody they know, and it's usually by somebody they trust and that they love. It's not just a random stranger. So perpetrators often threaten and they manipulate children to keep them from telling anyone. So many times they'll tell children things like no one would believe them. They threaten them with consequences if they do share what they may refer to as the secret. Also, children don't realize that it is wrong sometimes. Young children may have never been exposed to teaching, telling them that sexual behaviors between adults and children are wrong. Which is another reason why when children start school and they get that curriculum that you guys are teaching is really important, because they may not be getting that information at home. So what I'm going to do now is I'm going to quickly go through some different types of abuse. Yes, Erin's Law is very focused on sexual abuse, but we do know that there are other types of abuse that can occur as well. So I'm going to go through these types of abuse and also talk about some common signs of abuse for that specific kind. And so you should have this PowerPoint available to you also, so that you will have all this information, because there are lists of things that I'll be kind of going through with you today. So you will have that available to you if you don't already. So first of all, let's talk about child sexual abuse. So child sexual abuse is going to be any sort of forced or tricked sexual contact by an adult or older child with a child. So usually the adult or the older child is in a position of power or authority over the child. So physical force is generally not used. Actually, it's not common that there's physical force used, since there's usually a trusting relationship, like I pointed out earlier, between the adult or the older child and the child who is being abused. So child sexual abuse can be forcing, coercing, persuading a child to engage in any sexual act, and it can be also non-contact acts as well. Exposure to pornography, communicating in a sexual manner, voyeurism, and things of that nature. And it is a crime punishable by law, and so our district attorney's office will speak a little bit more about that. So let's move to physical abuse now. So physical abuse, let's move to physical signs associated with sexual abuse, excuse me. So there are going to be With most of these kinds of abuse, there are going to be physical signs and then behavioral signs. And so I'll go over both of those with you. So some common physical signs associated with sexual abuse are things that a lot of times you as a teacher or school personnel may not see, but you might. So some of those things are pain, bleeding, or discharge in the genitals, anus, or mouth, vaginal infections, cuts or tears around the vaginal area or the anus, other physical trauma, which can be anything from rashes, swelling, things like that to the genital or anal area, persistent or recurring pain during urination or bowel movements, wetting or soiling accidents unrelated to toilet training, and sexually transmitted diseases. Now, these are things that you may not actually witness with your own eyes, but if a child says things to you that makes you believe that this could be going on, it's very important to be in tune to that. It could be a sign of sexual abuse. Some of the things that you guys will probably notice more will be more of the behavioral signs that can occur. And so these are going to be, when I say behavioral and emotional, that's sort of the same thing. But some of the things that you might observe in a child who's been sexually abused are things like anxiety, depression, a child with very poor self-esteem. They may avoid relationships with other people, sleep disturbances, a child who has a change in their eating habits, unusual fear of certain places or certain people, maybe a reluctance to be alone with a certain person, and also changes in moods that could include things like anger, aggressiveness towards people, towards their parents, towards siblings, towards pets, rebellion or withdrawal, runaway behaviors many times in our teenagers, and also changes in attitude towards school or academic performance. If you've got that child in your classroom that's just been a certain sort of student, overall a good student, most all of the school year, then all of a sudden you really start noticing some major changes with that child, and that could be a sign that something's going on. Not necessarily child sexual abuse, but that something is happening to make that child have more of just kind of a lack of interest in school, and a lack of interest in peer relationships and things of that nature, sports activities, things like that. Also, some other signs of child sexual abuse can be things like unexplained or frequent health problems like headaches or stomach aches. Also, a lot of times you will see the younger teenagers and older teenagers doing things like cutting, self-mutilation. They may think of themselves as being dirty or bad and may have suicidal thoughts. Also, things like regression of previously outgrown behaviors, for example, bedwetting or thumb sucking. Those regressive behaviors can be indicative of sexual abuse as well. And also, abnormal sexual behaviors or knowledge of advanced sexual language and behaviors, and particularly in younger children. If you have a second grader who tends to have a lot of knowledge or a lot of behaviors that look sexualized, that can definitely be an indicator that they've either been exposed to something of a sexual nature, or they could be the victim of abuse, or exposed to, a lot of times now we're seeing a lot of children exposed to pornography, and then because they don't understand what they saw, they may be acting those behaviors out on other children. And I do want to point out as I'm going through these signs, just because a child has one of these particular signs does not mean that they've necessarily experienced that sort of abuse. But when you see great changes in behavior or extremes in behaviors in children, or a sudden change, or you see a lot of these signs together, it's definitely, should raise a red flag with you. Okay, moving on to physical abuse now. So physical abuse, of course, is physical injury that may result in substantial harm to the child, or a genuine threat of substantial harm from physical injury to the child, including an injury that is at variance with the history of the explanation given. That child or that parent just gives kind of an odd explanation of how that actually happened. That should raise a red flag. So some signs of physical abuse, and these are things that you would, most likely you would be observing with your own eyes. If a child shows up to school and they've got a lot of unexplained bruises, bites, broken bones, black eyes, they may explain, as I pointed out earlier, their injuries in kind of a strange or inconsistent way when they're asked about them. Also, if you have a child who has been absent from school quite a bit and they show up back up and they've got kind of some faded bruises or other marks, could be that abuser kept them from school for a little while just so that those fresh bruises will not be seen. So that's also could be a sign of physical abuse. They seem frightened or they cry when it's time to go home. That could be a sign. Or child reports the injury by a parent or caregiver. A child just may come out and tell you with physical abuse, more so with sexual abuse, what's happening. Also, kids who have been through physical abuse many times will be very self-destructive, aggressive. They may abuse pets or other animals. They may seem afraid of the adults in their lives that might be abusing them. Many of these kids may even run away frequently as well. All right, so let's move on to neglect now. So neglect, of course, would be failure to provide needed food, clothing, shelter, medical care, supervision, such that may impact a child's health, safety, and well-being. And some signs of neglect may be things like a child who is frequently absent from school, begs or steals food or money. They lack sufficient clothing for the weather. They state no one is at home to really provide them care. These may also be the children in your classroom who are very sleepy or tired a lot of the time. They show extreme loneliness and they really need a lot of affection. Also, they show an obvious lack of needed medical, dental, or vision care. Also, these are the children many times that will show up to school very physically dirty and have body odor. And also, neglect can manifest itself in kids actually using alcohol or drugs once they get old enough to where they can access those sorts of things. And you have to also realize too that many of these kids are in homes where that is easily accessed in their actual home, even for the younger kids sometimes. If ever talking to a parent who may be the one neglecting the child, there are some things to think about there. So neglectful parents may kind of seem not to care about the child. The parent themselves may seem depressed or just really not interested in anything at all. That neglectful parent may behave irrationally or strangely as well, or they may themselves be abusing the alcohol and drugs. That neglectful parent may also deny that the child has problems and maybe even blame the child for the problems that they're having at school or at home. Neglectful parents many times will also talk about their child negatively quite a bit. And they may also expect the child to do too much or to be too perfect most of the time. Neglectful parents also may use the child to be fulfilling their own emotional needs rather than being attuned to the emotional needs that the child may have. All right, so let's move on to emotional abuse. So emotional abuse would be inflicting mental or emotional injury to a child, or causing or permitting the child to be in a situation in which the child may sustain some sort of mental or emotional injury that results in an observable and material impairment in the child's growth, development, and psychological functioning. Children who've experienced emotional abuse may many times exhibit the following signs. They may have speech disorders. They may have delayed physical development. There may be substance abuse issues there. There may be ulcers, asthma, severe allergies that the child has. Habit disorders such as rocking or biting or sucking their thumb. Also antisocial or destructive behaviors. Delinquent behaviors, especially in adolescence. And also these children who have been emotionally abused may be developmentally delayed as well. And in my experience of interviewing children about all sorts of abuse, for instance, I interviewed some kids a few months back and they had been experiencing lots of things in their home, but when it came to them talking about the emotional abuse by the parent, although there had also been physical abuse, that was the thing that really hurt them the most, was the emotional abuse, and that's at the time in the interview that they would really tear up, and it was really, really difficult for them to talk about. So although that may not necessarily be something that can be prosecuted in court or be a crime, it really, really has a big impact on a child when they experience that sort of emotional abuse. And a lot of times children who have been physically abused and neglected also experience this type of emotional abuse, and children who have been sexually abused as well. So what we find is that many times that actual first report that's made may be of one sort of abuse, but once the case is being looked into, the child's being interviewed, law enforcement and DHR doing their investigation, we find that that's just kind of the tip of the iceberg, and they're actually victims of many other types of abuse as well. So that's one thing to think of, you know, as a teacher, that you may only have a little bit of information, but it could just be the tip of the iceberg, and always report if you have a suspicion, because there could be more to it than you actually realize. And quickly, there's also something called inadequate supervision. So that, of course, is going to involve failure to provide supervision that protects children from serious physical harm or sexual abuse. And so some factors to consider when thinking about inadequate supervision are, of course, the children's age, physical and mental condition, you know, their developmental stage that they're currently in, particularly as they relate to the ability to be able to make sound judgments about providing self-care and protection. Also the child's location and the parent's presence, or is the parent easily accessible to that child? Frequency and duration of occurrence is also something to think about as well. If you ever have concerns that a child is being left at home by themselves, or being left with a younger sibling to care for that younger sibling, that's something to really, you know, have a concern about, and to call the DHR, or you can call the Child Advocacy Center. We can kind of talk you through those things. We're probably going to go ahead and tell you to immediately call DHR and make that report if you have those sorts of concerns that are going on. So what we know is that children from any race, any socioeconomic level, any background, any geographic location can be victims of abuse. In my almost 15 years of working in the Child Advocacy Center field, I have interviewed children who come from very affluent households all the way to those who are living in more high-risk areas. So it can happen to any child, so just be aware of that. But what we do know is that there are certain risk factors for victimization where a child can be at higher risk to be a victim. And so these are things to be mindful of. Children who are disabled, chronically ill, or maybe perceived as different can be what abusers consider to be an easy victim. Many times these children do not understand what's going on because of their disability, or they maybe cannot verbalize what's happening to them, so that's why the abuser chooses them. Another risk factor for victimization is when a child is living in a home where there are lots of family dysfunction, or a family member or the family in general experiencing a very big life crisis, because they're very focused on that crisis that's happening at that point. So the child may not be getting the care and the supervision that they need, and so they can easier be victimized by others. Also, another risk factor would be substance abuse by family members, or parents who themselves have a physical or mental health problem. If a child is in a home with a lot of domestic violence, also research shows that they are definitely at higher risk for being abused. And just in families in general where there's poor communication. When you have a family who's not communicating, not teaching their child about how to keep themselves safe, and those sorts of things, that puts that child at higher risk because they don't really understand abusers and abuse and tactics that abusers may use. And so also many times parents who are young or single parents, those kids in those households can be at higher risk at times as well. And I'm not saying that as a blanket statement, but there are some households where they're at higher risk. For instance, you may have a single parent who's just trying to make ends meet. That parent may be working multiple jobs just trying to put food on the table and have shelter and clothing and the things that their family needs. So that child may be around lots of different people being cared for. while that parent is working those multiple jobs. So of course, that many times means that that child's around a lot of different people. That parent may not exactly realize all the people that their child is being around. They're just trying to make ends meet. So that child is going to be at higher risk for something happening to them because they're around lots of different people who are providing care for them. So let's move in now to, for a few minutes about why kids don't tell. For many people that don't do like what I do and the other professionals that will be speaking to you do every day, it's kind of hard to understand, well, if an uncle of a child started sexually abusing them, why wouldn't they immediately go run and tell? And I know I've already talked about this a little bit, but there are multiple reasons why kids don't tell, which is why another important reason why the curriculum you guys are teaching them is so very important, because they're not getting the education many times at home. Most children that I've interviewed over the past 15 years about sexual abuse, most of those children have not immediately told. They have delayed greatly in disclosing the abuse for many, many different reasons. And some of the reasons why they don't tell are things like they're just fearful. They're being threatened by the abuser and manipulated by the abuser. And as I pointed out earlier, most of the time the child loves and knows the person that's abusing them. And so they, even though that abuse is happening and they may not like it, they still don't want their loved one to get into trouble. And they want that loved one's acceptance and approval. Many times kids feel shameful, they feel embarrassed about what's happening to them, and many times that's because of things that abusers are saying to them. They may even feel guilty themselves, like they allowed it to happen when it's actually not their fault at all. And then, as mentioned earlier, just a general lack of understanding of what's happening, which causes much confusion when sexual abuse starts happening, especially to a younger child. So there's a lot of self-blame. And also, children have been taught to respect adults and authority figures. So that makes it extremely difficult for them to talk and to tell about it as well. Kids don't like to see adults in their lives that they care about upset. And so that in itself is just a reason why they may not tell. They may not want to upset the loved one. They may not want to upset their parent by telling about another family member abusing, because that would be hard for their parents who trust that person. Many times they don't tell because they just want to protect a loved one, a pet from abuse or harm. Many times abusers will say things like, if you tell, I'll kill your mom, or if you tell, I'll kill your pet dog. And so things like that happen, and children are trying to protect those people from any harm, and so they don't tell for that reason. Many times children just think, nobody will believe me, and that's what they're being told many times by abusers, that they won't be believed if they were to tell, so they just decide not to tell. And then also there is the fear of, if their loved one finds out, their mom or their dad, who they really love, finds out that someone that they know, love, and trust is abusing them, they're scared that that parent might go do things, take it into their own hands, harm that abuser, and they don't want that to happen. And then there are kids in households where they feel like, well, this abuse is just sort of a private matter. It shouldn't be talked about. Maybe it's being handled within the home, but they feel it's private, or maybe they're even being told, we don't need other people to know the business. And so they are the kids that feel, you know, they've been told it's private and shouldn't be talked about. And then, as stated earlier, the younger children. Younger children may think what's happening is normal just because they don't have the knowledge yet that what's happening is wrong, especially to do with the sexual abuse. And then there are also the kids who may have told someone. They may have told a family member. They may have told another trusted adult that they have in their life, and unfortunately that person did not believe them and didn't do anything to try to protect them from it. So that is another reason why they just may decide not to tell it anymore, because they weren't believed the first time. So talking to children is one thing that's really important to understand. And if a child comes to you in the school setting, they decide that you as their teacher or their counselor is the person that they want to trust with their deepest, darkest secret that maybe they've been thinking about the whole school year, and they come back next week to school and they decide, I've got to tell my teacher about this. The thing I want you to think about is your reaction and your response to that child can either encourage that child to continue to know that it's important for them to tell, or if your response is not what it should be, it could really shut that child down. So think about your, reacting very responsibly if a child gives you information that is really, really difficult for them to tell. First of all, remain calm. Don't panic or express shock. So control your feelings. You can avoid frightening the child or causing them to feel guilty or embarrassed by just really controlling your feelings and remaining calm. Be warm and caring. Don't express anger or blame, although it's quite normal that you would feel angry about a person harming a child in your classroom. However, don't say things like, "Why didn't you tell me? Why are you just now telling someone?" Because that makes that child blame themselves even more. Also, just reassure the child and let the child know that they did the right thing and that you were very glad that they told you that information and that they're very brave and that it's part of your job to help protect them and make sure that they're safe. Also, just assure the child that it's not their fault, because most kids who have been through, especially sexual abuse, will feel very much like something's their fault that because it's happened. That they are not, and let them know that they are not bad because of what's happened. Most importantly, and this will be talked about also with some of the other professionals, don't ask leading questions. Just do more listening than talking. And also, when a child comes to you with information such as this, just please keep the information confidential. I don't mean not make a report. Make those appropriate reports, but please remember that this child has just opened up to you about something extremely difficult. And so remember, just keeping that information to the minimum of just who needs to know that information, just keeping that confidential. Okay, the last thing I'm going to talk about before passing it on to Marilyn with DHR is when we're talking about disclosures in children. Children many times are not going to just come right out and tell you just this beautiful, like, this is exactly what happened, this is exactly how it happened and where it was. They may give you more of an indirect disclosure or more of a disguised disclosure. So an indirect disclosure may be something like, my brother wouldn't let me sleep last night, or Mr. Jones wears funny underwear, or my babysitter keeps bothering me, so I don't like Grandpa anymore. So there could be some sort of indirect disclosures being made that should prompt you to maybe gently encourage the child just to tell you more about it. Like I said, no direct questions, or don't jump to the conclusion that it is abuse, but what do you mean? Tell me more about why you don't like Grandpa anymore. And then, so a child may talk in these terms because they haven't learned more specific vocabulary yet about how to express those things. Also, children may give very disguised disclosures, and that's when a child may say something like, I know someone with a touching problem, or what happens if a girl tells her mother that someone was touching her? Would her mother believe her? And so there are things like that children may say that can be kind of a disguised disclosure, and so it's very important to be, aware that sometimes that is the way kids are kind of testing your reactions and testing about what you might tell them about what's going to happen if they were to actually tell. And just always remember that a suspicion is enough to make a report. You don't have to have a bunch of evidence. You don't have to have interviewed the child, and we don't want you to do that, and we'll talk more about that. But that is all that I have, and I'm going to pass it on to Marilyn Colson. And please reach out to us at the Child Advocacy Center at any time if you just have questions about anything that we can help you with. And thank you for all that you do.
Good morning. I want to thank the Board of Education for allowing us to have this time to remind all of you again about reporting child abuse and neglect. I'm Marilyn Colson from the Department of Human Resources, and I just want to say thank you to many of you who have reported in the past. I know I've been the director at DHR for 8 years, and I know of a number of cases in which your activism in reporting child abuse led to saving children from serious abuse, a life of serious abuse. So thank you for that, and I know that you will continue that. Teachers and school personnel are mandatory reporters, and Act 26-14-5 of the Alabama Code specifies that you are mandatory reporters, and failure to report when you're aware of child abuse and neglect is a misdemeanor and can lead to a large fine and even some prison time. I think I'm looking over to the DA to see if that's correct. I didn't bring that note up, but he'll address that also. But it is a mandatory thing that I know that you all would want to do anyway. The requirement is that the reports are made to either the Department of Human Resources or law enforcement. And the importance of you being aware of that is that sometimes teachers think, well, I told my counselor, I told the principal, I told my co-teacher, I reported. No, you have the responsibility yourself, if you know of the abuse or neglect, of reporting to DHR or to law enforcement. Now, that's not to say that if you're aware of, in the morning, a child comes in and discloses physical abuse to you and you can see the bruises on the child, but you have a class, you can't leave that class. You can let your counselor know about it to go ahead and notify us, because it is better when there is immediate risk of harm to children that we find that out as early in the day as possible. It gets real antsy for all of us when we have an immediate risk of harm for a child and they're about to get on the school bus. So that's just another tip. And then you can later follow that up with a direct report. There is a written report that you can make. It is Form 1593. There should be supplies of these probably in your counselor's office at school, and you can complete those and you can scan and email them to the intake worker. You can fax it to our office. It's always good to call and let us know you've sent a fax, or you can mail it. But of course, if immediate risk of harm situations, that needs to be a phone call. So how do you make the report? Well, you call our intake worker. We have an intake worker that will receive calls all day at the office, and you just call our number, 205-280-2000, ask for intake. Our regular intake worker is Bethany Chancellor, and she will ask you a lot of questions. And these are questions that we have learned that we need that information from the get-go, because it helps us make a better decision, assessment decision. So don't be frustrated with the fact she's going to ask you a lot of questions. If Bethany is out for the day, there will be some other worker that will be taking the reports. You can also make calls if something comes to your attention on the weekend or at night. You can call communication with the Sheriff's Department, and if it's very serious, if something's happening at that moment and you are aware of it, call 911. But otherwise, you can call communication at 755-2511, and they will get in touch with an on-call worker. We have on-call workers on call all night, all weekend. When we receive a report, now if we receive a report from school personnel, we're going to take that very seriously. It's very few reports we ever screen out from school personnel. And the reason for that is we know that you see these children every day. You know their patterns, you know what they say that may be imaginative, but you also know what they say that may be very true. You know them, and we don't. So if we get a report from you, we're very likely to accept just about any report that comes from the school setting. However, there are some reports that we get from the public, or maybe occasionally from school personnel, that do not rise to the level of child abuse and neglect. The family is still an important entity in our society, and it's like there's a sanctity to the family, that we have to recognize that we just can't go barging into people's families without very good reason. So occasionally there are times that we screen out reports, and those are reports that it may just, and I hate to go into examples, but say a child is dirty. And we have had this, where neighbors have called and said, this child is dirty all the time, they're just not taking care of the child. Well, just that does not rise to the level of child abuse and neglect. If the child is being supervised, if the child is being fed, if the child has adequate housing, is not being physically abused, there's no other signs, we're probably not going to take that report. But as I said, most of the time from the school setting, we take those very seriously. So when we get a report might be screened out, but if it's accepted for assessment, if there is an indication of immediate risk of harm, and that means that a child is possibly in danger right now, right this minute, or if they're going to be in danger when they get off that school bus or when they get picked up in the car by possibly a parent that's under the influence that would affect the safety going home. That's an immediate report, and we're going to respond immediately. So what can be the outcome of our assessments? Well, some may be not indicated. We do get reports that after looking into the situation, there's no basis for it, no apparent basis for it. If we assess a report, we go out, and of course home visits are required, contact with collaterals are required. If it's anything involving medical or physical issues, probably contact with a medical personnel is required. So if we identify that there is a safety problem in the home, and that is our primary responsibility, is the safety of children. We do not work to create perfect homes, family situations, and we don't work to create middle-class homes and families for everyone. We work to create minimally adequate homes for children where they can be safe and have their needs met. So if we go out and there is an immediate or even an ongoing safety problem, one of the things that we might do is do a safety plan with a family member or a family friend who we determine to be safe. And that involves interviewing that person, interviewing other people that know them, and also doing a cursory background check to the extent that our agency is able to get that information. So a safety plan would be where the parents who have legal custody, or whoever has legal custody of the child, agree for that child to stay somewhere else and have someone else be responsible for them while we continue to assess the situation to see if we can make it safe at home. We have 45 days, and if that safety plan cannot be resolved in 45 days, then we are either compelled to let the child go back home or to file a petition with the juvenile court. Now, the petition with juvenile court is a dependency petition, and if it is granted, that means that either the court can order the parents to do certain things. It might be possible for the child to remain at home and the parents get involved in treatment programs, or the petition can be granted by giving our agency custody of the child. Even when children are in our custody, we can place with relatives if they pass background checks and can be proven to be a safe alternative. The removal of custody from a parent is a very serious thing to do, and it is our last resort. We do try to work with family members, other relatives, anything we can to have to remove a child from the people that they know and that they love. Even if they're being mistreated, they often would choose to stay, and they always want to go back home. not always, but 9 times out of 10, a child that's removed from their parents is going to want to be returned to their home. So that is our first goal, is to keep the children at home if we can, and if not, to work toward reunification. By state law, parents have 12 months to show that they have made significant progress in solving the safety issues, whatever they might be, whether it's drugs or they might have a mental health condition that needs treatment, but whatever the problem might be, it might be an unsafe living environment, they have 12 months to make significant progress, or by law, our agency is to file for the termination of parental rights. And when that occurs, then adoption can follow. I do want to make a comment about, we often hear the opinion from folks, not so much from teachers, but it could be that, well, I called DHR and they just didn't do anything. I mean, we hear that often. Well, even if you're a neighbor of a family that you've called us on, you may not know what's going on. You may not know that we have that parent in drug treatment. They may not have shared that with you. You may not know that we went out, we checked every way that we could, and we couldn't determine that there was enough evidence to take action regarding the family at that time. And in regards to your reporting, I know that I've had teachers say to me, well, I did report and y'all weren't able to find that anything was wrong, and I know it is. Well, again, you see these children every day. You know them. When we go out on a report, I mean, we're lucky if they let us in the first time, so without a court order. So we see a slice of life. We see a moment in time, and you're seeing the big picture. So let me encourage you, if you make a report and we're not able to assess that it is supportable at one moment, make it again. And make it again if you have to. And it's not that we're not doing our job, it's that our intervention and ability to take action involves, legal requirements, and just keep reporting. And again, there have been times, I remember one specific case where the school had reported absenteeism. The child just wasn't coming to school. Well, I mean, by law, we can't remove a child just for that. But you all kept reporting, and we kept assessing, and finally, after a number of contacts, we determined that this child, there were drugs involved in the family, but worse than that, this child was being terribly sexually abused by her family members. And it took a number of times for us to talk with her, for her to develop the trust that she was willing to share that. And she was removed and never went back. The mandatory reporter training that I believe that the Board of Education requires that you participate in once a year, and that's the computer-based training, is on our website. It's at www.dhr.alabama.gov, and over on the left side of the page, you go to the quick links, and then if you scroll down, you can see the mandated reporter training. If a child comes into our custody, what happens then? Well, placement may be with relatives, placement may be in a foster home. If the child has serious problems, the child may be placed in a treatment program. As I said, after a year, if the family's made no progress, then TPR, termination of parental rights, and adoption can occur. In Alabama, not in Alabama, in Chilton County, last year we had 16 foster parents adopt children. Well, it was 16 foster children that were adopted, and there weren't that many homes, but it was 16 children that were in foster care were adopted by their foster parents. And we're, very proud of the fact that Chilton County does reach out to these children and does help them. Since 2008, when I became director at DHR, there's been 145 foster parent adoptions. So if you know of anyone who is interested in being a foster parent, adoptive parent, please have them call us about that also. You can call the same number and just say, I need information about being a foster parent. We desperately need more foster homes to be able to meet the needs of children. We like to match them, you know, by their socioeconomic background, by the area of the county they live in. We like to keep them in the same school if we possibly can. And teachers make great foster parents. So please get in touch with us if you're interested. And thank you so much for this time, and I hope to be hearing from you.
Good morning. My name is Janice earlier, Shane Mayfield. I work for the Sheriff's Office. I supervise our investigative division that has both the fortunate and unfortunate responsibility of investigating crimes like we've been talking about today. I want to talk about a couple things that would help us be successful in our investigations and that you could help us with. First is documentation. When children disclose to you an act of abuse or whatever it may be as a crime, then it's important to document exactly what that child says, exactly what the child says happened. Because when we go through the court process, that may be a year and a half or 2 years. And while it's not wrong to get up in court and say, I don't recall, it's certainly not helpful to that child or not helpful to us trying to help that child if we had that information and we didn't write it down. And there's another side note to that, is that we've got to convince 12 people generally that that child's statement is true. And unfortunately, a lot of these cases are what we call he says, she says. The child says it happened, the offender says it didn't. There may be some phrase or there may be some word that that child used to describe what they disclosed to you that will convince that 12th juror that that child is being truthful. So we want to document exactly what the child says during that disclosure, do that as quickly as possible and provide that to law enforcement, because we'd be able to provide that information in court. And if you're like me, a year and a half, 2 years later, my hair's turned a lot grayer than it used to be, and I have trouble recalling what happened 2 years later. We want to document that where we can get up in court and be able to say those things that are factual. Some people are hesitant about becoming involved because of the court process, and this is how I tell people about the court process. It is nothing different than we do every day in our general lives as we talk to people, especially you in education, as you talk to groups of people in classrooms every day, and you sit there and you tell the truth. You answer questions truthfully, you tell what you saw, what you heard, you say what happened. There's nothing hard about the truth, there's only one of it. The only different problem that occurs in getting up and telling the truth in court, there are lawyers involved, unfortunately. But there's nothing hard about it. Court is court. It's just telling the truth, sitting down, raising your right hand and saying what you heard, what you said, what you did. Second thing about interviewing or asking questions on potential victims and students that disclose abuse to you, as well as other students that may be offenders. When a child discloses, certainly listen to everything that they've got to say and document that well, but stay away from asking questions or it becoming an interview or an interrogation of that child. That's what Jana and her people are trained to do, just like you and I are trained to do our jobs, they're trained to do theirs. And they will get that information through a process that not only is less traumatic on the child, but they know the information that we need for prosecution. They know how to get that information in a way that could be presented in court, and that we need to let them do their jobs. Another reason for that is, and you deal with children more than I do, is that if a child tells a teacher, a bus driver, or custodian that they trust, they're going to may tell a lot more then if they go to the principal's office and the principal starts questioning them about it, then that's an authority figure. That's the person that's usually the disciplinarian in the school. So they may not tell as much to the principal as they did to the person they originally disclosed to. So not is it not true, but it's not as much and it's not as detailed. And if it gets down to a police officer or someone else in authority that they're less familiar with interviewing that child again, then we're going to get even less information because the child is already scared. They've already told 2 people, now I'm told 3, now I have to tell 4. And each time you're probably going to lose a little bit less information, and they may even start telling it in a different, not necessarily being untruthful, but telling it in a different manner because of the environment that they're in. Well, what that does in court is the defense attorney is going to say that's 4 different versions, which one is true. They're all true, but because we've interviewed that child so many times, then it looks like the story has changed. So starting to listen to what they said, document, but as far as the interviewing of the people who disclose abuse, then we're going to let one interview, do that one time by people who are trained to do it, who know how we're going to use it in court. That way we don't have any issues with that. As far as interviewing potential offenders that are also students, especially in sexual abuse crimes, those are crimes that our society deems to be one of the most heinous offenses that we deal with. We only have one opportunity to do the first interview with that suspect. And to get someone to admit to committing one of our society's most heinous crimes is oftentimes difficult. There's a process. We go about it in a certain manner. There's a process that we go through. And part of that, if that person has already been made aware of the allegations, if those persons have already been interviewed or questioned about it, a criminal offense by a school employee, then they know that I'm aware of it, or whoever the investigator is, and they're going to start forming a narrative in their mind. They're going to start saying, if he asked me this, then this is my answer. If they ask me about this, then this is my answer. I'm not going to get those sudden pauses, or I'm not going to get the stumbling moments in the interview when I interview them for the first time, because it's not the first interview. So we're much more successful in criminal offenses if these people have not been interviewed and not been made aware of that they're a target of investigation or they're a subject of investigation. There's also a little bit, and I've had this come up one time, there's also a little bit of a legal issue. I know all of you have seen it and read people's rights on television, their Miranda rights. I've had the issue that in order for Miranda to attach and to be used, not everybody that gets arrested has to be read their rights, that you have to be in custody and it has to be an interrogation. And a lot of people think in custody is, okay, I'm handcuffed, I'm in a police car, I'm in jail. In custody is you are not free to leave. That is basically the definition of in custody. So if I'm in the principal's office or if I'm in the counselor's office and I'm a student and I've been called there, then chances are I feel like I'm not free to leave. And if I'm being asked questions about a criminal offense, then that would meet the definition for interrogation. I'm not saying that you should Mirandize people as teachers or school board members. That's obviously not what I'm saying. What I'm saying is a competent defense attorney would make the argument that any statement that that person gave was given while they felt like they were in custody, and it was obviously an interrogation. So be real careful. Let's do the interviews for that reason, and for interviews that first time generally is all we've got to do that with. Marilyn talked about the mandatory reporting laws. People are hesitant about getting involved because of the court process and different things. We've got SROs in all the schools in the county now, so that should make, the original purpose of that is keep our schools safe, but utilize them for this as well. If there is an issue, then hopefully there's a deputy or police officer that's no further than a few minutes away from you that you can make that report. So it doesn't have to be a big issue of calling someone or trying to get in contact with somebody. Then bring it to that deputy, that police officer's attention, tell them what they found, and then hopefully they will be able to proceed, and you won't have to worry about making all the issues that I just talked about. Cell phones are a big issue now. Jana touched on pornography. That may not necessarily be a form of child abuse all the time, but it may be that that abuser has taken pictures and sent to that child, or it may be that something the child has taken pictures of that was part of that abuse. Electronics devices are a big part of our investigations now. We're a communication-driven society. If a phone is involved in that, then certainly we want to get that as evidence. And you know your board policies as far as administrators as to what you can do to take that evidence or take those devices. But if there's some reason to believe that an electronic device is involved, then we certainly want that. The only thing that we would ask is, in the majority of cell phones, it's pretty easy. Go to the settings function in the menu, and it's usually the very first or second thing at the top is to put that phone or that device in airplane mode, and that takes that device where it can't see the internet. And that prevents that if the offender does find out that, you know, the gig's up and I found out that I'm doing something to this child, he can't get on the cloud or whatever the stuff that I'm not competent in and go into that phone and remove that picture from the cloud where it's not on that device or it's not on there anymore. So putting it in airplane mode, and of course all the SROs should know how to do that. So again, rely on them if you're not feeling comfortable doing that. The big thing that I'd like to push as far as we're concerned is I go back to the documentation, because I have to, or investigators have to, create a case file that may be 100 pages long to go to the district attorney's office. It has to be reviewed for them to see if it is a case for prosecution. If we go to court, it's obviously scrutinized by defense attorneys, and then we have to sit down with and make our case to 12 people like you and I, who come from 12 different walks of life. So that's sometimes a difficult task, but document everything that child says or everything you see. If you're taking a photo, takes me 5 minutes to sit down and explain what a bruise looked like, or where it was at, or what I think happened. Where if I've got a photograph, I just hold the photograph up and those 12 jurors go, oh, okay, I see what happened. The photographs are big. If you're not comfortable taking photographs of something, again, reach out to the SRO and say, hey, would you look at this? You think we need to document this? Take a photo of it, and I assure you they will do that. And it may be that one word, when we've talked to juries afterwards in cases where we either won or we lost, then it was sometimes come down to a single word or a single sentence or a single phrase that either they didn't like and was a reason for not guilty, or something that the child said or a witness said that did ring true to them and is a reason they voted for guilty. So I can't overemphasize the importance of documenting exactly what happened and exactly what you see. That's about all I've got to talk about our perspective, and I'll let CJ talk about as far as the prosecution. And I wasn't talking about him in the lawyer part, so when I made my lawyer joke.
Good morning. My name is CJ Robinson with the District Attorney's Office for the 19th Circuit. Covers 3 counties, Chilton, Autauga, and Elmore County. And before I jump into some of the stuff to follow up on what you've already heard this morning, I want to talk a little bit about the legal process. And the reason why I want to do that is it's the same. Whether you become a witness in a case, whether, God forbid, one day a case is against you, whether you just have a friend or family member who has went through or going through or may go through this process. And in the program materials that's been provided, there should be a diagram. I don't have that behind me at the current time, but I'm going to do my best to try to point to the wall behind me back there. So just bear with me here, and hopefully we'll get through it. Will they be able to see the No? Okay. Well, I'm just going to point, so hopefully this will make sense. If this was a diagram of the legal system behind me, anything starts at the beginning with an investigation. So if you had to start up here, the tip of the leaf would be the report. The report kicks off the investigation, and that's kind of what we've talked about today is the mandatory reporting requirements. So if you come in contact or you believe that child abuse has happened, you file a report. You contact DHR, you contact law enforcement. That kicks off the process. That's like the start of what we do. So once the investigation is underway after the report is made, after the report's made, you have the investigation. Well, the investigation typically goes one of two ways. Either once the investigation is completed, maybe law enforcement decides to make an arrest. Maybe they decide to present the case directly to a grand jury. But know this, I want you to pretend that this is the grand jury here, okay? In my diagram, this whole part, this big part is grand jury. And that's the biggest part of what we do because all felony cases make it to the grand jury. Now they get there different ways, but all cases end up here. They're coming from different sides. So if you're coming from an arrest, report, investigation, arrest. If law enforcement makes an arrest, within 30 days from that arrest, there's what's called a preliminary hearing. At the preliminary hearing, we have to put on some evidence to show that we had enough probable cause to arrest someone. Now, when you think about jury trials, this is the burden of proof. It's beyond a reasonable doubt. It's almost 100%. All right, that comes at a trial. At grand jury, at a preliminary hearing, to arrest someone, this is not the burden of proof. This is beyond a reasonable doubt. This is probable cause. This is all law enforcement has to have to be able to make an arrest. This is all a grand jury has to have to indict someone. So, we have the report made, we have the investigation. If an arrest is made, within 30 days, we have a preliminary hearing. Typically, the preliminary hearing doesn't last very long. I have to put on some evidence to show why we arrested whoever we arrested. However, the case could also go to the grand jury through a direct present. Now, sometimes sex cases, much like what you may be someone who has to report about, end up in the direct present. And the reason is, a lot of times these cases are he said, she said. There may be no physical evidence. There may not be a rape kit. There may not be fingerprints. There may not be text messages or emails or pictures or whatever. So in those cases, sometimes a he said, she said case might get to grand jury that particular way. So you got the arrest over here, you've got the direct present here. But remember, all cases end up in this grand jury. Now, when the case gets to grand jury, one of two things will happen. In grand jury, if you ever get a subpoena or serve on that, there's no rhyme or reason. You get a summons in the mail, you show up at the courthouse. When you get there, they put your summons in a box. The judge asks some general questions, who lives here, who's over the age of 18, who speaks English. At that point in time, he pulls out 18 names. That is the grand jury. There's not really a screening process, it's just members of the public who hear the case. Now, two things happen once the grand jury hears the case. The grand jury can either choose to no-bill the case, which means it's over. If the case is no-billed, that means that the grand jury heard the case and determined there was insufficient evidence to move forward. All right, it's essentially dismissing the case. Now, if a grand jury hears the case and issues a true bill, also known as an indictment. So if you see the newspaper and it says so-and-so got indicted, that means the grand jury heard their case, determined there was enough probable cause for the case to go forward. Now, once the case goes forward, a lot of things happen. Once the case goes forward, you have an arraignment. At arraignment, I have to give the defendant every piece of evidence I have, okay? I don't get to get in trial and pull out of my pocket here the confession and say, okay, jury, here's the confession, and the defendant's never seen it. At arraignment, I have to give them every single piece of evidence I would use to convict them and their attorney. If you don't have an attorney, you get one at arraignment. About 6 weeks after arraignment, you're going to have a plea day. So the offender is going to have a chance to talk to his attorney and decide if he wants to plead guilty or she wants to plead guilty to, the crime of rape or robbery, murder, burglary, whatever. And after the plea day, if they determine they say, no, I'm not guilty, I want a trial, About 6 weeks later, we have a trial. Now, that can be longer or shorter depending on a few factors. We have one judge in our circuit that has about 20 cases on his trial docket already, old cases. We have one judge with about 30. We have one judge with about 100. Now, we can only try 3 to 4 cases in a week if they're all one-day trials. Sometimes we have bigger trials, like a murder case that may last a full week. Now, what I want to tell you about grand jury, it only meets in Chilton County twice a year. The grand jury hears roughly 250 to 300 cases over 4 days. So we're hearing about 500 cases a year, and we can only try about 4 cases a week. For every grand jury, there's an arraignment and a plea day and a trial week and a sentencing. All right, so if we have 3 judges, each judge has a trial week. For every grand jury, that's 3 trial weeks. So roughly we can try maybe 18 cases a year in Chilton County. All right, we're indicting 400. If everybody wants a jury trial, I can try 18 in a year. So this is how the process begins to take so long on some cases. I wish I could speed that up. However, that's the process. That's what we have to deal with. After the trial, if we do convict someone, about 6 weeks later we have a sentencing date, and that is where people go to prison or get put on probation or whatever punishment the judge deems appropriate. But all the stuff I just described to you are what happens on felony cases. All right, and this grand jury is the key here. It's like going to the movies. You can't get in the movies without a ticket. All right, you can't get in this arraignment, plea day, trial, sentencing without the grand jury punching your ticket in the indictment. Backing up a little bit to more of what we've talked about this morning, mandatory reporters. Again, I'm just going to reiterate a few things here. Obviously, you are hearing this information because you are a mandatory reporter. Public K-12 employees, private K-12 employees, higher education, post-secondary, all those job fields are mandatory reporters. Now, some questions we've had about that are, well, what if I'm not really an employee? Well, I'm going to get into that kind of when I transition at the end of, in a few minutes, when I start talking about some of the other statutes that do apply to school employees. Now, a lot of people in our 3 counties, because we cover Chilton, Autauga, and Elmore, have said, look, I don't want to get involved, but I'll tell someone. And I think you heard earlier in the presentation today about passing the word on. Well, that's not sufficient under the statute. Under the statute, when you discover facts or circumstances that lead you to believe or gives you a good faith belief that someone under the age of 16 has been the victim of abuse, you have the legal duty to report that abuse to law enforcement or DHR. All right? You can't satisfy that legal duty. All right? It's not a defense for you to say, little Susie told me ABC 1, 2, 3. So I don't really want to get involved, but I'll go tell the vice principal, or I'll go tell the principal, or the counselor, or the school nurse, and that way I've kind of pushed it up the chain. No, it doesn't work like that. That does not satisfy the statute. Now you can enlist their help, and I have no problem if you want to tell all those people, and then all 4 of you can call DHR, and all 4 of you can call the police or whatever. That's fine. But if you learn the information, the duty is yours to report. And nobody can satisfy that except you. Again, don't wait, report immediately. Well, okay, well, whom do I report? Well, that's an easy answer, because we've told you several times today, either DHR or law enforcement. Now, I believe Shane was talking to you just a few minutes ago, and he talked about some of the reasons why it's important for law enforcement to have that contact, that initial contact with the offender. Well, guys, look, in the world we live in, everybody wants information. Everybody wants to know what's going on. But listen, it's our job to interview victims. It's our job to interview suspects and defendants. All right? It's a nasty job. It sounds like it's a lot of fun. Sometimes it can be interesting, but it's our job for a reason. Let us do our job. We may only get one bite at the apple. All right? So if a child tells you what happened, and then you're in a group chat with 10 other people, and then you tell them, and they screenshot and tell 10 other people, well, guess what? That child may never get justice for what happened to them because you couldn't wait 10 minutes to go and share the information. And I'm not saying you would. I'm saying that this is something that has happened. I'm not making this up. It's true. It happens in this county. It happens in other counties. It's not specific to this county. It's just people how we're wired. We want to know what's going on and we want to share with other people. So my other cautionary tale to you is this. If you do that, all right, if you do that, or if you decide, well, I really care about this child, let me ask them what happened. So you began conducting this interview yourself, essentially. My recommendation to you would be the moment that you learn that abuse has happened, or you suspect that this child was abused, let us get involved. Because if you don't, all right, if you don't, here's what can happen, and this is very concerning. If you get involved at this point, it's kind of like being pregnant. Maybe I shouldn't use that example, but it is. Sorry, Malia. So if you do get pregnant, you can't just be a little bit pregnant. All right? You can't get just a little involved in the case. Once you talk to that child, you are now 100% a witness in this case. All right? And even if I don't have to give your name and all the information about you in this process that we talked about earlier up here, after grand jury, remember when I said I have to give the defense everything I know? Well, they get your name and all your information and your address and where you work here. And I'll get back to that in just a moment. But my point is, if you get involved a little bit, you're fully involved. But the law says you have a duty to report. You don't have a duty to do all this fact-finding. Let the investigators do that. Let the forensic interviewers, let us do our job when it comes to that. The most uneasy part, if you do get involved, is when we get down here and if we have a trial and you're called as a witness. All right, I may call you to the stand and I may say, okay, Ms. Smith, is it true that while you were teaching at whatever school, little Susie told you ABC 1, 2, 3? And you'd say yes. Well, the defense attorney then gets to stand up. And look, there's some good attorneys out there. I'm not trying to slam defense attorneys, but they have a job to do. And if you're testifying in a criminal case and you are testifying as to what this child told you, all right, even if a judge does allow that, and you testify to that, you're subject to cross-examination. And I'm not saying an attorney would ask you this, but I have seen attorneys who might ask you this. And so the defense attorney might stand up and say, okay, Ms. Smith, well, you asked little Susie about somebody touching her, didn't you? Well, yes, I did. Okay, do you do that with all your students? Well, no, but I felt concerned about her, so I decided to, try to help. Okay, well, who did you tell after you found out? Well, I told my principal. Okay, did you take the child with you when you told the principal? No, I just told the principal. Okay, well, did you record what you asked the student? No, I didn't record it. I just kind of paraphrased the principal. Well, you didn't, it was that concerning and you didn't report it word for word? Well, no, I just kind of told her what happened. Well, did you write it down anywhere? No, I just remembered it. Have you ever embellished anything, Miss Smith? Well, I try to be an honest person. Oh, really? Isn't it true in your divorce papers 2 years ago that you alleged that your husband had an extramarital affair when in fact he really didn't? That's the kind of stuff that can happen at trial. So my cautionary tale to you is you have a legal duty to report it and let us handle it. If you get involved, you're subjecting yourself to situations like that for the next 2 years. It's not worth it. Not to mention, you could obstruct the investigation and have the best intentions of the world. So let us get involved and let us do our job. How do I make a report? We've covered that. Contact DHR, contact law enforcement, your local law enforcement agency, or the communications, which is 755-2511. You contact them anytime. The weekends if it's DHR, or you can call DHR directly at 205-280-2000. Now, in addition to the people we've talked about and the statute that says all these people are mandatory reporters, that you have to report, the law also says anyone can report suspected child abuse. And think about it, the policy behind it is we want to protect children. So anybody can make a call to DHR or law enforcement and report suspected child abuse. Here's the catch, all right? It's got to be in good faith, all right? You can't help out your brother-in-law who's going through a nasty divorce by calling and saying that so-and-so abused a child. Because if you do that, that's called making a false report, and you can be put in jail for up to a year, all right? So that's bad. We don't want to do that. Obviously, we want to protect children. So if you have a good faith belief, anybody can report that. Now, when must I report? I talked about this a little earlier, but the statute specifically says if you know or you suspect that either neglect or abuse has happened. And here's neglect. Neglect is the negligent or maltreatment behavior put on a child, including failure to provide adequate food, medical treatment, supervision, clothing, or shelter. Obviously, common sense comes into play here. If you have a child who there's been no signs and it's a cold day and they come in without a jacket, that's probably not child abuse. However, you know it when you see it. So, and if you think you see it, go ahead and report it. Known or suspected abuse. Harm or threatened harm to a child's health and welfare. That's the more the physical abuse, that type of thing. What information must be reported? All right, so if I pick up the phone, what do I have to tell them? Well, the professionals, we will guide you through that process, but there's not a ton of information that you have to share. If you know this information, this is what the statute says that you have to tell us. The name and the whereabouts of the child, because we want to protect that child. Name and addresses of the caretakers. We want to know where that child is staying, where they're going. And the extent of injuries along with any pertinent information like previous injuries or if they said who did it. Now look, you don't have to go through this big detective mission to find this out. Most of this information will be on file at the office, but we need to know from you there's a problem for us to find out. Now, what is the penalty if I don't report? And Marilyn mentioned this earlier, but any person who shall knowingly fail to report by this chapter is guilty of a misdemeanor and punishable by up to 6 months in jail and a $500 fine. That's the penalty for a mandatory reporter who doesn't report abuse. Now, a question I get asked a lot, can I get sued if I file a report? Well, here's the good news. Any person reporting suspected child abuse or neglect, all right, anyone who makes a report, the law says you are presumed to be acting in good faith, and you are immune from any legal action against you. So if you have a good faith belief and you report child abuse, you cannot be sued. All right, somebody can't come and say, oh, they defamed my character, they made this up about me. No, if you were in good faith, which doesn't mean it has to be true. It means you have to believe the abuse is happening, you're covered. Now, you make up something to help out a buddy in a divorce, yes, you're going to get sued for that, you're going to get prosecuted for a false report. But if you're acting in good faith, you cannot be sued. So you literally have nothing in this world to lose if you believe abuse is happening by calling DHR, by calling law enforcement, and letting them check it out. The last thing I want to cover for you very quickly is there's a few statutes that we have specific to interaction between school employees and students. And the first one is a Class B felony. The range of punishment is 2 years up to 20 years in state prison. And that statute is actually a school employee engaging in a sex act with a student under the age of 19. Now, the age of consent in Alabama is 16. In the state of Alabama, once you become 16 years or older, you can have sex with anybody you want to. Good, bad, indifferent, that's the law. With the exception of if you are a school employee. If that is the case, then it's a little different because it's not 16, it's 19. All right? And here's why. The public policy is we want to protect students who may be around school employees in positions of authority over them. All right? Now, what exactly is a school employee? Because it's more than what you may think it is. A school employee, administrators, teachers, coaches, student teachers, volunteer coaches, volunteer parents sometimes, depending on the situation. If they have any authority, even in any extracurricular situation, over a student. All right? So it's not just the people on your payroll. And you need to know that, especially those of you administrators who are approving any kind of volunteer hires. You know, so I know you need bodies, but it really matters on who you're letting around these children. Now, if a school employee, anybody I just mentioned here, engages in sexual intercourse or deviant sexual intercourse, so you have sexual intercourse or any kind of behavior involving oral or anal sex, regardless whether the student's a male or female, that part doesn't matter, it is a Class B felony. You will be a registered sex offender. You will serve time in prison up to 20 years. Could be as little as 2, could be as much as 20, whatever the judge deems is appropriate. And guess what? The student can say, you know what? I'm 100% good with whatever this teacher did because I consented. Doesn't matter. You are the person of authority. You are deemed to have more self-control than this student. Now, one step under that, we have a school employee having sexual contact with a student, all right, under the age of 19. So everything I said just applies, but this time instead of intercourse, a sexual touching. Now, we don't have to be brain surgeons to know what that means. So if that situation happens, that's a Class C felony. The range of punishment is 1 year and a day up to 10 years, whatever the judge deems appropriate. You will be a registered sex offender for the rest of your life. One step down from that, this is a Class A misdemeanor, which means the range of punishment is up to 1 year in the county jail, not state prison, but you will be a registered sex offender if this happens. A school employee soliciting a sex act with a student under the age of 19. So again, if a school employee solicits, persuades, encourages, harasses, or entices a student to engage in a sex act, this is limited, but including but not limited to sexual intercourse, deviant sexual intercourse, or sexual contact. So if you
Don't know what happened there. Sound cut out.
All right, after a quick word from our sponsors, we're back on program. The school employee sexting law. All right, if he or she is a school employee and you distribute or transmit by any means, so phone, Snapchat, text, whatever that may be, obscene matter. So if it's a naked picture, if it's something obscene, whatever that may be, that's a Class A misdemeanor. And finally, I want to say this in closing. Thank you so much for listening to everything we said today, and I know we've covered a lot of material and we went really fast, but these are the last few things I want to share with you. And if you didn't hear anything else I said, please listen to this. I believe people are good. I really do. We see a lot of the worst society has to offer, but I think people want to help, especially if a child's being hurt. So we need your help. In law enforcement, we have to have your help. Almost every case involving a child is a he said, she said case. So we need you as a witness to help protect not only this child, but the next child that could be a victim of this same offender. And this is a long process. You've heard today it could go as 1 year to 2 years, depending on what Okay. All right. In closing, just what I wanted to let you guys know is this. Thank you for staying with us. We need your help. We've got to have your help. Almost every case is a he said or she said. By you helping and assisting us, letting us do our job, you could protect not only the child that was hurt, but the next child that could be a victim of this offender. And it's a long process. Sometimes it takes a year to 2 years, depending on a lot of factors, what cases are on the docket, which judge it gets. Hang in there with us. We'll get to the case. We can't make it go any faster, but when we get there, we will do you justice when the case gets time. And documentation is key. You heard Shane say, you know, make good detailed notes. And the reason I say that is because the case may take so long to get to court and get resolved. So much is going to happen in a year to 2 years. You may not remember the smallest details that could be really important to help us get a sexual predator out of the community. Because if you didn't document it, when you get in court, attorneys will say it did not happen. Don't discuss the case, and I mentioned that earlier, but the more people you discuss the case with, the more people can be called as a witness to testify that you told them facts in a different way. And that's going to bring your credibility into question. So when you learn this, let us know and then let us take over. And finally, this is my last point, misinformation is rampant. In this age of social media, it is worse than I have ever seen. We as people want to know what's going on. We want to be involved in our community. We want to snoop on other people, however you want to say it. All right? It's life. It's what we have to deal with. And it's not just this county. It's everywhere. So on social media, everybody now has a voice. All right? Very few people know the true facts about what is going on. And those of us who do, we will not be posting it on social media. So when you come to us and say, y'all said, all right, what your neighbor put on social media about the case is not the DA's office. It's not Butterfly Bridge. It's not law enforcement. So just remember, when you see that and you share that and you comment on that or you go somewhere and talk about what you read, there are real people whose lives have been wrecked by the worst thing that has ever happened to them up to this point. And when you do that, it causes deep wounds. They have to relive it over and over. So just know, misinformation is worse in this age than it has ever been, especially when the case drags on. So just please be aware that there are real victims and there are families impacted by every one of these cases. That's all I have. At this time, I want to turn it over to Michelle Coppage, and thank you so much for your attention.
Good morning, everyone. Welcome back. I obviously am going to be talking about something different than what you've heard this morning. I appreciate all of these different community members who have come and spoken to you. And while I will not be speaking on Erin's Law, this is a mandatory training that relates to special education. And there are so many things they have said this morning that obviously child abuse, child neglect, those are definitely things that are so important. But some of the same principles that they talked about are going to be some of the things that I'm going to mention to you. This is a yearly training, so some of these you've heard before. So just as a reminder, please make sure with special education records, but with all records, that you have confidentiality of your students at you hold that in the highest regard. It is very important to keep lots of information confidential, but particularly regarding the status of that student as a student with special needs or who receives special education services. It is very tempting, and they've mentioned several times, social media and so many things that are said there. It is often tempting to come into those conversations and offer information. It is often with very good intention, but you must remember that the status of these students is confidential. Their needs, what you're doing to meet those needs is confidential. There are paper records, there are electronic records. You just have to make sure that you are holding those things in the utmost confidence. That means we're not leaving those things laying around on desks. Letting students take information regarding other students that may have special education information in it, that we're not, entrusting them with that information. That when we are releasing information regarding the special education status, that we're making sure we receive permission for that. that we are destroying information appropriately. If you have copies of IEPs, if you have information regarding that special education status, that those are shredded, or you contact our office in terms of how to discard those informations. But the more important process that I want to talk to you about and just remind you is your obligation for Child Find, our obligation for Child Find as a district, as educators. What the law says is that it is our responsibility to look at children and to recognize anything out of the ordinary. You've heard lots of information this morning about some things, about picking up on things that just aren't right with students. Those are obviously of a different nature. But there are often times where there are things and you think this is just not exactly right. And that is what we refer to in educational terms as Child Find. And we do all have that responsibility. As a teacher, as an educator, anyone who has a concern, you can let us know. That is a Child Find issue. If you have if you have reason to suspect, if you will reach out to us and say, I think this child possibly needs an evaluation. That is what our office is here for. We run those notices in the paper. It is for educators. It is for parents. It is for anybody who says, I think I need some educational assistance with my child. We do have to go through at least that referral process in terms of recognizing that someone feels like a child is a child that could be in need of assistance and who could be a child who qualifies for special education services. We are required to provide that meeting to have you attend, and that's why it's often important to make sure you have all the educational documentation when we come to those meetings so that you are able to share with us what your concerns are. If we feel like we need an evaluation or if we feel like we don't, that is supported and documented well through any information that you may have. Any teacher, special education, general education, administrators, you are part of that team. And if you have important information that regards that student, you can be a member of that team. We certainly can evaluate and determine if a child is eligible. And if they are found to be eligible for special education services, then we develop a plan for that student. And that is also your privilege is to be on those teams and to offer the information that you have about those students. There is a certain amount of time that we have. We have to do this in a timely fashion. So if you're a general education teacher, we may ask you to help us fill out behavior rating scales. You may be conducting observations. And there is a certain amount of time that we have to complete that so that we are not dragging that on, that we are timely looking at those things in a timely manner, that we are considering attendance, that we are considering everything about that child that's impacting them educationally, which doesn't always just mean their grades. It can mean emotionally, socially, functionally. There's a lot that we have to consider. You are a member of the team as a general education teacher. It is not just special education teachers. The power you have as a member of that team is to bring good information, whether you think the child needs support or does not need support. And while you don't always have the authority to unilaterally make a decision about an accommodation or what you think they need, you do have the power to bring that back to the team, which includes the child's parents. It includes you. It includes the special education teacher, administrators, anybody that can understand what it is that child may need. That is what the team approach is, so that we are all weighing in on every different situation that child may be in. It is also important for all of our students to attend school. That is why oftentimes, educationally speaking and special education speaking, that we will look at the length of their school day. They've got to attend like everybody else, and if they don't, that's something that has to be addressed. It's not something that we can just decide, but it has to be handled appropriately, that they have the same educational benefit. That includes when we're looking at discipline in students who have special education services to make sure they have access to that education that they need. Our office is always, all of my staff is wonderful. That here in this office you can reach out to any of us by email, by phone. We will be happy to answer questions, come and meet with you if you have specific questions. We have the opportunity to see a lot of you in meetings, and we're so thankful for your participation. I know sometimes it seems frustrating, but you are part of that child's team, and you're an important part of that child's team, and you're important in helping us know how to make the appropriate decisions for students. So thank you very much. I wish you a great second semester. We are very excited to get started.